Hofwig and the community councils have done some further scrutiny of the conditions in the context of their earlier submissions. So instead of using that original agenda, as we discussed yesterday, what I'm going to do is look at the condition that Hez is interested in first, and then use as a proxy agenda the email that I circulated last Friday, where I listed the conditions that I was happy to accept aspects of Hofwig and the community council's comments on. Now, I know we've got noise people and environmental health people here, so I think it'd be particularly useful to make sure we cover the conditions that were raised initially by Hofwig and the community councils, which I think covered noise, shadow flicker, private water supplies and fire safety. But there's quite a lot else on that list that we can hopefully get through as well. So before we get on to the conditions themselves, can I just confirm from the parties who's participating for each party in this? I'll start with the applicant.
Thank you, ma'am. My name is Amy Howard. I'm a solicitor at Wright Johnson Mackenzie. I will be leading the condition session for the applicant. Marcus Trinick, KC, on my left, will also assist with a couple of the points. Peter Brooks, to my right, will be able to answer any points relating to noise. And Graham Kerr and Gavin Shirley of the applicant may input if required, but maybe not. Thank you.
Thank you. And the council?
Thank you. My name is James Finlay, King's Counsel. To my right is Rob McIntosh. I don't know why I'm getting feedback. To my right is Rob McIntosh.
Off for a second.
To my right is Rob McIntosh. To his right is...
And we also have Paul Cooper and Mark Nichol from the Council's Environmental Health Service who will input into the noise conditions.
Thank you very much. And Hez?
Thank you, ma'am. Douglas Milne of Morton Fraser McRoberts. I'll be speaking in respect of condition 37, joined by Dr. Iona Murray of Historic Environment Scotland.
Thank you. And Hofwig and the community councils.
Representing John Campbell, representing Hofwig, and Mrs. Patterson is to my left. Ms. McLean, planning consultant, is to her left. Ms. Fiona Bick from the community council is to her left, and Mr. Louis Backwell, from whom you've heard before, is to her left. That's the team for conditions. Obviously, not everybody's going to speak about every condition. We tried to. Obviously not everybody's going to speak to every condition.
Okay, that's grand. And as I said, we're going to start with condition 37 on cultural heritage tree management scheme, and I'll let the applicant start on where we've got to on this condition.
Thank you, ma'am. Just to check what document you have in front of yourself showing this condition. Yes, we have the same document. And those are the track changes. Just to check we have the same track changes, which deletes the word "and maintenance" on the fourth line of the condition. Right. Quite simply, we accept the Hez version of the condition that you see there. We are content with it.
Okay. Does Hez have anything to say on that then?
Yes, I'm grateful to Mr. Trinick for the conversation we had earlier. He confirmed that position on behalf of the applicant. What Hes would like to emphasise, really this is already included on that note at 15.47, that if consent is granted for the Hill of Fair wind farm, that will be on the basis that the harm that Hes has identified, which the applicant does not accept, that harm will have been accepted by ministers. This condition should therefore be regarded as being compensatory in nature and does not negate that harm. It does not negate the significant adverse impact on integrity, which forms the basis of Historic Environment Scotland's case. What I would also like to mention, with apologies for not having raised this with Mr Trinnick earlier, the condition, of course, is suspensive in nature. No development shall commence until a scheme for the management of trees has been submitted to and approved by the Planning Authority. But of course, at the very end of the condition, there's an enduring requirement to comply with the tree management scheme, which means, ma'am, that you and Scottish ministers would need to be satisfied that that condition could be complied with by the applicant throughout the life of the consent. And I don't have any information on that, with apologies, Mr Trinnick, for not having raised that with you directly earlier, because that's a helpful point to know what the applicant's position is on that. Thank you.
The applicant's position is that we are content to be bound for the lifetime of the consent. But in terms of are we able to be bound for the lifetime of the consent, this is a suspensive condition. We will have to demonstrate that at the time of the discharge of the condition.
Okay, does any other party have a comment on this? No? Then that is, you happy that's covered?
Thank you very much, ma'am, and grateful again for starting at the end of the list. Ma'am, if it wouldn't be impolite if the Historic Environment Scotland team could now leave quietly, that would be much appreciated.
No, that's fine. Thank you very much, and thank you for your contribution to the inquiry.
Thank you very much, ma'am, for the inquiry and for the way in which matters have been conducted. Thank you.
Okay, we'll carry on. I had, just remember on the agenda, I did have a couple of general questions at the beginning that it might be worth still looking at before we get into the rest of the conditions. One was on the principle that I think had been set out around usually not referring to specific statutory consultees in conditions. And I think I'd asked a question about, I really think it just flags the fact that we need to remember that some statutory consultees have asked to be named, some have asked not to, but we can maybe pick that up in the individual conditions that we go through.
Amy and I are purists on conditions. We like drafting good conditions. And in principle, we don't like seeing references to consultees because a planning authority will consult with people as appropriate. And we don't want to hamstring them or indicate what they should do. However, I'm not going to die in a ditch over it. If someone thinks it's useful to add a particular consultee to a condition, well, fine.
Yes, ma'am, I'm afraid I take the opposite view, at least in respect of where it's appropriate. And principally, the wish is not for the local authority to notify, but for the applicants to take the trouble to notify the community councils when they wish to start developments. So, for example, number 2, you haven't got to it yet, but number 2, I'm suggesting the insertion of community councils there as persons to be notified. It's not a big effort.
Okay, I'll take those views. I'll move on to the list then in my email of Friday the 5th of September. The first few conditions on the list, 1 to 6, are the consent rather than the deemed planning condition.
Sorry, which one are you
1 to 6.
on?
I'm on a general. I'm just on an introductory point.
It's just I didn't hear you, sorry.
Okay, I think I'm speaking a bit tireder and quieter today than I have been. So conditions 1 to 6 are conditions that would be attached to the section 36 consent rather than deemed planning permission. The council has said it doesn't really take a view on those because it's not responsible for them. Hoffwig, I think, is generally agreed with those conditions. So can we just check which of the conditions 1 to 6 you were wanting to make a particular point, and I think you've just mentioned condition 2 and wanting community councils to be consultees. That's correct?
Well, but yes, I know. I'm proposing, just for complete accuracy, the insertion of the words "and local community councils" after the words "the planning authority" in line 3 of condition 2.2. Just again, line 3 after the word "the planning authority" and local community councils, and in condition 3 the same, only it begins in line 2 this time. Don't think there's anything else. Yeah.
And could you just briefly explain why that's a request?
With my community council, so that we know when things are starting, basically. Thank you.
What does the applicant have to say on that?
The applicant doesn't have any issue with notifying the community councils.
Thank you very much. Hoffwig, you had mentioned condition 5 on the Pawini's radar. That's a condition that's been agreed with the aviation interests. Are you content if the aviation interests are content?
Yes, we are.
Is condition 8 and 9, you'd made this, one of the comments you'd made was comment both of those, and it was that you would like conditions to state that cables between turbines, and I think it was between turbines and the substation, should be underground. I think that is what's proposed in the application. I was just going to check that.
Yes, that's correct. That's what is proposed, and again, the applicant would have no issue with that being specified in the condition.
Thank you. The next condition on my list is condition 11 on micrositing. SEPA had made some requests in relation to limitations on micrositing in peat. And Hoffwig had asked whether the updated site layout plan that's mentioned in this condition could be submitted more quickly, so within 1 month rather than 6. And I think you'd given an example of where that timescale had been used. Can you comment on that, please, applicant?
I think the only issue with that is the condition as drafted says 6 months from the date of first commissioning, which is the date in which electricity from the first turbine is exported, and therefore the final layout might not necessarily be confirmed within 1 month of that date. However, the applicant would be happy to agree to within 1 month of final commissioning.
You have a comment on that, Hoffwig?
Yes, that's fine. Thank you. I'm much obliged.
Condition 13, in the long set of additional comments that Hofwig had submitted, there are a number of matters listed which I've asked whether the applicant could clarify are already addressed in conditions. Do you have the list? Do you have the long list with you?
I've got it here. I think my understanding from your email was, is it just the first section, the first list of comments that you wanted us to comment on? Okay, no, thank you. So in relation to point 1, I believe it's the text in bold that's not included in the applicant's proposed condition. And our review is that that's not necessary. That's a high-level description of what the SEMP is to include, and paragraph 2 defines exactly what's to be provided in the SEMP, so that detail in bold there just isn't necessary.
Have a response to that?
There are other items in that list. Energy storage, compound formation, installation of energy storage equipment, which you have added. And then elements in the planned historical environment protection plan, wet ecosystem survey, tree felling management plan, construction methods statement, and a phasing plan.
Sorry,
I'm just looking to check which matters I meant to include, and the conditions aren't all numbered. Sorry, so I'm just trying to catch up on which one it is.
So the question through you, of course, is why have those matters been omitted? Why have those matters been omitted?
Sorry, ma'am, are we dealing firstly with subparagraph 1 of the Hofwig comments? So I think we've gone on to consider other matters. The point about item 1 is that all that paragraph 1 says is there will be a plan which will be submitted, approved, and will be informed by site and ground investigation works. We don't need to specify in that paragraph what will be contained on the plan, because that's all done in paragraph 2. That was Amy's point. That was the exact point you asked, so, yeah.
And I think some of the other comments that aren't amongst the ones that I'd accepted here, they fell into the category of, I think you'd gone through the model conditions with quite a fine-toothed comb and picked out things that weren't included. And generally, I've not accepted those if it was just a comparison with the model rather than a reasoned comparison that picked out why that was necessary in this case. So sometimes there's something that I think is covered or something that I think might be relevant, but otherwise if I've excluded it, it's for that reason. Okay. Condition 14's on that point around naming consultees. I think you'd suggested that SEPA should be a consultee, and I think SEPA hadn't asked that. Do you want to comment on that position? Okay. Condition 15, you'd made some comments on burrow pit blasting, and you can see from my email that I thought your comments were broadly in line with the council's position. The council has agreed that condition with the applicant. Are there any outstanding points to be made on this? No. Okay, condition 16, construction hours. The council had agreed some variations to the hours in the model condition, and I thought for Hofwig and the Community Council's benefit, council could perhaps explain why it had been happy to accept that flexibility.
Thank you, ma'am. We went back to the original conditions as drafted, and the variation to the 4 p.m. working on Saturdays was quite frankly a meet in the middle between the initial position we put forward to the applicant and the position they had put forward to ourselves. There's obviously a balancing act to be struck here between protecting amenity as part of the condition, but also the implications of restricting work will likely cause the construction period to last for a longer amount of time, a greater amount of time. So that was why we felt it was appropriate to agree the wording as is.
Do you have any comments?
We would much prefer an earlier stop on a Saturday afternoon, 12 o'clock rather than 4.
Even if it meant a longer construction period?
I think so.
I'm going to move on to condition 18 on abnormal loads. And again, a suggestion was made about who should be named as consultees in the condition. Do you want to clarify what you were looking for on this condition?
Simply to include Transport Scotland and Police Scotland, certainly for the abnormal loads, condition 18, and condition 17 to include Transport Scotland and Police Scotland for the traffic management plan. These are very small, narrow roads that we're talking about, difficult to negotiate, and the only routes to some areas, so it really needs a lot of detailed work and support from the bigger picture.
Ask the council, do you think they'd be people you would normally consult in this type of situation?
Thank you, ma'am. From experience, it's not entirely uncommon to consult with Transport Scotland, but such a provision is usually off the back of Transport Scotland asking to be consulted on those matters. Within the council, we do have our abnormal loads or structures team that would be involved in the routing and approval of that, but certainly in my experience I'm not sure I've come across Police Scotland being a consultee to such conditions.
The big point here is, if I may say so, the last point that Mrs. Patterson made, these are very narrow roads. They serve farms, and there are certain times of year when farming traffic is very heavy. For example, harvest, carrying, and so on. So we don't know what the schedule is for these abnormal loads yet. Of course we don't, but when they are scheduled, they've got to take account. It's quite usual, in my experience, for the police to be involved, if only for escorting purposes, but also to help the farmers and other members of the community adapt their operations to suit the abnormal delivery.
And what's the applicant's comments on this?
Notwithstanding Mr Trinnick's comments about naming consultees in the condition, I don't think the applicant would have a specific problem with naming Transport Scotland in both conditions, noting that I think they have asked to be consulted in their consultation response. And in relation to the police are required to escort abnormal loads as it stands, and therefore the sort of timing of deliveries will be dictated by police availability.
So the police become involved, but not generally through a condition. They become involved just through those negotiations.
That's correct.
The next condition on the list is condition 19 on the BEMP. There had been, I think, some further written submissions that were relevant to this, which included comments on how matters might be addressed through conditions. I just wanted to check whether those further written submissions, suggestions being picked up in this condition.
So in relation to the first point, which I think is the applicant's further written submission in relation to wildcats, I think there may be an error in that written submission where it says that protected species surveys would be provided as part of the final biodiversity enhancement management plan. Protected species surveys are provided as part of the SEMP. There's provision for that in that condition. I'm just scrolling up to check the number. Yeah, so part 2L of condition 13 deals with protected species surveys.
Okay, thank you for that clarification. And another point on this condition was about the council's position on off-site measures. I think Hofweg and the community councils had said measures should be provided on-site. I just wanted to clarify the council's position.
Thank you, ma'am. That refers to a comment we made on an earlier draft of the conditions. It was simply a point we were raising to seek clarification that the site was large enough to deliver on-site enhancement measures. We consider this to be relevant to the drafting of the conditions because if off-site measures were to be proposed, there's a higher risk of non-delivery, particularly if they involve third-party land, and that would have shaped our view as to the appropriate trigger point for the delivery of the enhancement measures. However, as we understand it, the measures are to be delivered on-site, and that's why it is no longer a concern for the council.
Okay, did you want to comment on that?
Comment on that one? No, that's fine. I have a couple of other comments on that condition.
Okay, I only accept comments that you can.
The FWS, in response to matter 9, Res also committed to include invertebrates.
Speak up.
Sorry.
Sorry, ma'am, we can't hear very well.
Sorry. Yeah. In Res's FWS response to matter 9, Res also committed to include invertebrates as a condition.
Thanks, ma'am. So the applicant's comment in the further written submission in relation to invertebrates was that they were a good indicator of habitat condition and that surveys could be used as part of the habitat enhancement measures to show the success of the measures that have been put in place. And these surveys will form part of the proposals that are put forward in the final biodiversity enhancement management plan that's to be submitted to the planning authority for approval.
Okay, so they'll be in there, but that you're suggesting that doesn't need to affect the wording of the condition itself?
No, it'll be with all of the other proposals that will be included at the time of submission of the scheme.
Are you happy with that?
Yes, thank you.
Okay.
And just an informative, which we included in an FWS, we'd like to request the setting up of an independent group with local representation to oversee any environmental mitigations put in place. Completely independent, and it's an analogue to the Viking Wind Farm Environmental Advisory Group that has been quite successful up in Shetland.
Okay, does the applicant have comments on that?
Could Hofweg, could you just clarify what you have in mind as how the group would operate in connection with the biodiversity enhancement plan? Not quite sure how it works.
So what we wrote in the FWS was that Certainly in Shetland, the particular group has representatives from various organisations like SEPA, Nature Scott, Peatland Action Team, RSPB, meets a couple of times a year, and its purpose is to support the developer in making sure that environmental impacts are minimised and agreed restorative procedures are implemented, and to advise the Council on the execution of the approved plans for the development. The group is there to work with the developer so that its members can share their environmental expertise and knowledge, not to carry out site visits to check on the development. It has no regulatory role. You may be aware that around this area there are a lot of experts who know a lot about the biodiversity on the hill, and we're willing to work with you to make sure that its damage is minimised.
I can see that as part of the biodiversity enhancement plan there will be a management group there's bound to be, as there are in all these plans. I see absolutely nothing wrong with your idea in that context, that the local representatives being part of the group. Nothing wrong with that at all. If that's what you're proposing, then fine.
Thank you.
Okay, thank you. And just to clarify, again, that wasn't for the face of the condition, but that was how matter within the BEMP would work. Yeah.
We take that as a condition. We take that as an expression of goodwill if consent is granted, and whether it's, well, just that, an expression of goodwill and cooperation. I'm sorry to be tedious, but it's either a condition or it's not. I think it's not, really.
No.
I understand why you're saying that. If, ma'am, you see a way to writing something into the condition, but the trouble is that we're not there specifying in the condition anybody who should be on the group. So selecting one group out of many, it just starts to get an inclusive list, which is never very satisfactory.
I could record that intention otherwise, though. You know, I could reflect where I'm writing in the report about a relevant matter, if you're happy that I record that and that intention.
But the statement is made here today in good faith.
Okay, so the next condition that we're looking at is condition 21, operational collision monitoring. There's a couple of points in here. Firstly, you've suggested that the word bird is specified, so it's clear you're talking about bird collisions. I assume that's not controversial. Second one, again, you'd picked up that there was relevant content in further written submissions on this matter, though I've noted, I think the applicant on this one does seem to have included in the condition what it said it would do. Is that correct?
That's our position, yes.
Are you happy with that? Okay. Oh, so it's similar question on condition 23, compensatory planting. Are the matters that the applicant set out in the FWS that are relevant to conditions picked up in the condition?
So for the written submission, the applicant agreed to the use of a chartered forester. So we're happy for that to be included in the condition. I would suggest that the proposed condition could be amended so it currently reads, no felling or development shall commence until a woodland planting scheme, and then I suggest we add comma, prepared by a chartered forester, comma, and then continue with the rest of the condition to compensate for, just to incorporate that commitment into the wording of the condition.
Thank you. Are you happy with that? Yep. You'd raised condition 24, but said that you'd defer to the heritage bodies In this case, I think the relevant body is the council and the conditions agreed by the council. So are you happy on that basis? That's a yes, okay. Condition 26, peat management plan. I'd noted that SEPA have commented on matters relating to peat at the application stage. Could you just summarise what's the outstanding issue, if there is one, that you wanted to raise?
Just to ensure that SEPA are indeed consulted.
Okay.
I think, ma'am, you were wanting us to follow up in writing just to some of the queries that you'd had on the original agenda, just confirming how the requests made by bodies such as SEPA and Nature Scot have been incorporated into the conditions, so we can certainly do that.
Yeah, that's right, and that is something I've asked for as a generality. There were a number of questions on my original agenda where I'd asked really for a bit more joining the dots between something a statutory consultee who isn't objecting had asked for and where that's how that's reflected in conditions, so that will be coming in writing. Next condition is condition 27 on the Dinect Estate private water supply, and there had been requests from both the community councils and Hoffwig on widening out the scope of that a bit, and I understand there's been some work done on that, if the applicant would like to outline that.
Yes, it was clear at the community session that there were concerns, and perhaps belatedly, and I will say that on behalf of RES, we acknowledge that the private water supplies condition needs to cover all properties and not simply a named property. It needs to cover properties out as far as they need to be covered and not simply within 2 kilometres. So the condition we've drafted, which you have in front of you, aims to do that. It follows it's a method statement approach on a pre-commencement basis, so no development shall commence until our method statement's been submitted and approved. And it will envisages, first of all, you identify the properties that have the potential to be affected, and there's no great science in that, it can be done. Secondly, you detail the measures you propose to secure quantity, quality, continuity of the water supplies. In other words, during the construction process, how you will seek to avoid interference with private supplies. And thirdly, what you propose to do if you go wrong and something happens and the water supply is interrupted, whether in terms of quality or quantity or continuity. And then it says, of course, obviously the method statement should be implemented as approved. That's what we put forward. It does recognise, as I say, the need to cover all potentially affected properties, but it also covers in paragraph B, as agreed with the Dinect Estate, their private water supply. So we've got that in as well. So I hope that is satisfactory.
And what would you like to say on that?
Accept the premise, though, which is that it needs to be comprehensive and be a pre-commencement condition. So, in other words, it's a full-scale study of PWS is likely to be affected. I'm not quite sure how you deal with likely to be affected, but Mrs. Bick might have something to say about that. But I accept the premise. I'm not just sure yet that I can accept the wording, but if I don't agree with the wording, I'll say so in my closing submission.
Yes, so I mean, it is a welcome development, indeed. However, I think from the point of view of the community councils and our constituents, I think the key issue is how all private water supplies that have the potential to be affected will be identified and who will be doing the identifying. I would say that we don't think the planning authority necessarily has the expertise to to oversee that aspect, and we would like some oversight of it as well. We would like to be consulted, in other words.
The community councils.
I think the community councils, yes.
So we've suggested an informative. We propose to set up an independent group to monitor private water supply and ensure compliance to the conditions, as well as a rapid response to complaints from the community. And we propose to set it up for about 6 years to cover pre-construction, construction and post-construction activities.
And can I just clarify where because there's a couple of points where you've listed something as an informative, and I just wanted to double check, are you informing us, or are you asking that actually goes as an actual informative on the recommendations and any decision? Okay, thank you. Does the council have some comments on these issues?
Thank you, ma'am. Appreciating that we only saw the amended wording this morning, the approach that's outlined is generally in line with what our expectations would be with the pre-commencement aspect of the condition, and using that to identify levels of risk and mitigation that would be undertaken. So at a high level, it largely accords with what our expectations would be. However, on the point relating to oversight and who would be involved in the identification of particular stages, that's something we would like to consider further and respond to as part of our closing submissions.
Does the applicant want to say anything more now, or see what comes in?
No, the essence of success in this is direct communication with those whose water supplies might be affected and with local community. Sometimes they're very obvious, but the source of the water supply is not always so obvious and needs to be pinpointed, and the catchments need to be identified. The exercise is reasonably well known for upland wind farms. It's been done many times before, but we thoroughly welcome the involvement of a local group with whom we can communicate in order to make sure that all the water supplies are identified correctly, and that group should remain in existence so that liaison can take place during the construction process. So that would be strongly welcomed.
Can I just record our disappointment that after 3 years of telling you about this, we only received something last night following the community hearing on Monday evening?
You're absolutely right, and we accept that criticism.
Okay, I've recorded that. Thank you.
At the end of 27.1, you might think it appropriate to add "and the community councils," or following consultation with the community councils. That's after the words planning authority. Thank you.
And yeah, if you include that in your closing submissions and any other comments you've got on the detail of the wording, then the applicant can respond.
This is just a drafting point, but the reference to the Dinect estate would have to come out. 27.2a.
Yeah.
Just to raise that SEPA specifically asked for those measures to be secured by condition.
So my understanding is that there needs to be specific condition on the Dinect estate private water supply because of SEPA's position, and that this condition widens out so that that specific requirement for SEPA is still there, but it's widened to cover all properties and contingencies. Is that right?
That's correct.
The next few conditions on my list, 28, 29 and 30, all relate to different aviation matters. And my understanding is that those conditions have been agreed with NATS and Aberdeen Airport as relevant, and that's why they're not here. Is that correct?
That's correct.
And are Hofwig and the community councils content if those bodies are content.
Yes, curious but content, thank you.
And I just wanted to check with the applicant that there's not any further conditions to come on aviation. All the anticipated mitigation measures that you are discussing with the bodies would be covered by the conditions as they're set out.
Yeah, everything will be covered by the currently proposed conditions.
And at the moment, I think both bodies are they're still formally registered as objectors whilst the negotiations are still underway. Is that correct?
NAT submitted an official withdrawal of their objection either yesterday or the day before, and it should have gone to the case officer.
And what I'll do with Aberdeen Airport just is if that doesn't happen with them, I might just need to get some further updates or clarifications. If I ever get towards the point where I'm finishing a report and I need an update, I'll request one.
Yeah, I think in Aberdeen Airport's either the consultation response or the hearing statement that they prepared for this session did say that if their objection was still outstanding at the time of the decision, then they would ask for the agreed conditions to be imposed.
Condition 32 on redundant turbines. I think, Hofwood, you were wanting SEPA to be a named statutory consultee on the condition, is that correct? And what's the applicant's comment on that?
I would need to double check just to be sure, ma'am, but I don't believe SEPA have asked to be involved in that process.
Okay, yeah, if you could check that, that would help. Condition 34 on the financial guarantee. Hofwig and the community councils had made some comments which were broadly in line, I think, with the council's original comments on this condition, but since then, I think the applicant and the council have agreed a condition. Is that right?
That's correct.
Does Hofwig have any further comments on that? No. So condition 36 on operational noise. Now this was, I think, the last condition that you've come to agreement.
We ought to touch on 35.
You're quite right. Condition 35 is on shadow flicker, which was in the Community Council's original conditions hearing statement. And again, this is a condition that's now agreed between the council and the applicant, so it may be helpful to just get a brief overview of what that condition provides for now, and then we can see if there's outstanding matters not covered.
Could I come in first? Because that condition now doesn't say mitigation, it says avoidance. There will be no shadow flicker. That's what the condition says. And that, noting a comment that was made in one of the earlier sessions, is a very standard process using photosensitive software. Nothing manual needs to be done. It is applied on numerous wind farms and they automatically turn off in the relevant conditions. This has been there for 25 years.
Okay.
So avoidance is what's promised here, not mitigation.
The issue, right? I'm sorry.
I was just going to, I just meant to clarify my understanding of what the implications of that change are. So my understanding is that what you're proposing now is more of a proactive approach, that where you have identified that shadow flicker may occur, you'd take steps from the outset to make sure it doesn't. Is that right or wrong?
It is part of the setup of the turbine when it's erected that the photosensitive software is built into the machine such that in relevant conditions the turbine will not operate. That is what happens, and as I say, it has been done for 25 years. This is not new. So it's not so much proactive because if there was a mitigation scheme, the same would be applied, but the software would be instructed not to turn them off all the time, but only down to 30 hours a year or whatever the threshold was.
And you were still looking for
Well, the
mitigation as well?
definitional issue is the one that always arises in this, considering this condition. Properly defined shadow flicker is where the turbine is between the sun and the small window, and a stroboscopic effect is created inside the dwelling. The concern of the community is that, plus the issue of shadow casting. It arises in this case because we have much larger than usual turbines, and therefore shadow casting is likely to be an issue. It's possible that it will be an issue, we don't know. And so what I'd like to hear from the applicant is how they propose to deal with that. Of course, large turbines will cast a shadow if the sun's in the right place. But I want to know if the applicants are sensitive to this issue, because representations made to me and those I act for have identified this as a real problem, or potential problem, sorry.
Do you propose to deal with that?
No. The only solution for a fear of shadow cast is to turn all the turbines off every time the sun's shining. Well, obviously that's a non-starter. It's not recognised as an issue which needs to be addressed in evidence. It's not been discussed in evidence. And I'm not being brutal, I'm just being blunt. No, we're not going to propose to do anything about shadow cast as opposed to shadow flicker.
Okay.
Okay, well, you need to be cognizant of it, and I'll leave it with you how you deal with it. But I think it's worth mentioning that the provisions about a statutory nuisance do not exclude a phenomenon of that kind. Let's leave it like that.
Okay. And there were further written submissions on this matter as well, which I'll look back to.
There were further written submissions on this matter, yes.
That's what, yeah, there were, yes. Okay.
Thank you, Ma'am. I just wanted to come in here on the Community Council's request for to include a further paragraph within this condition which provides for complaints to be investigated, investigated and measures taken to avoid shadow flicker if there are properties that have not been identified by the applicant as being at risk, but which in fact are experiencing shadow flicker, and that those properties should have the benefit of a specific procedure to allow them to complain and have their complaints addressed.
Okay, so that's if something occurred somewhere that hadn't been predicted and therefore might not be covered in the condition as is. Do you have a comment on that?
The scheme to be provided will define, I mean, this is a scientific matter. It's not a matter of planning judgment that you might or might not get shadow flicker. It's a matter which can be calculated. The scheme will calculate the properties which could be affected by shadow flicker, and the scheme will provide for the shutdown of turbines as necessary to avoid shadow flicker at the identified houses.
Right. If I
have to say it again, certainly not shadow
Well, I'm just
casting.
wanting to be sure, that's all.
Mr. Trinick referred to the scheme identifying those houses that are at risk of shadow flicker, but I believe that that's likely to be, or perhaps he can assure me that it's not, doesn't have a definitive cut-off of 10 times rotor diameter.
No, I don't. I wouldn't try and impose a 10 rotor diameter cutoff. It's whatever it is when you identify what might be affected. It ends at about 10 rotor diameters, but that's not precise.
Ms. Patterson?
Yes, I'd like to bring to your attention the proposed informative that the Community Councils propose once again to set up an independent group to monitor shadow flicker and ensure compliance to the conditions, as well as a rapid response to complaints from the community. And we propose to set this up for 5 years in the first instance to cover not so much pre-construction, but construction and post-construction activities.
Thank you. And I just suggest to the applicant, I think there's a couple of instances where informatives of this nature are suggested in the submission that came in from Hofwig and the community councils, and I might only have picked up one of them in my list, so it'd be worth looking back at all of the suggested informatives on the additional Hofwig Community Council submission. So you can cover those in the closing statements if you wish. Yep.
Okay.
Could we just perhaps comment on the suggestion of a complaints procedure? The council wouldn't be opposed to that being included within the condition, should you deem it necessary to do so. However, we would urge you to perhaps consider stating the level of detail within the procedure akin to that contained within the noise condition, so it's very clear as to timescales for complaints, so that it's very clear as to who is carrying out monitoring and when the information is to be provided to the council, etc., and that mitigation is to be submitted, agreed, and then implemented, should you go down the route of including that provision within the condition.
Thank you. And you're saying that the timescales, etc., in the noise condition would be similar?
Could I, ma'am? Thank you. I could just say that in terms of noise, if there's a complaint of noise, then there's a long procedure to go through in terms of engaging a contractor on the part of the applicant or the operator in order to put up noise monitoring equipment and so on and so forth. In the case of shadow flicker, there is no need to engage a contractor to go to do these things, and therefore the timescale should be very much shorter.
Correct.
Move on to condition 36 on operational noise. So this is the final condition that the council and the applicant have come to agreement on, and that's since we saw the original hearing statements from Hofwig and the community councils, both of which talked about this condition. I thought it might be helpful to start by just giving a brief overview of how the operational noise condition works and what it essentially covers now, so that we can then see whether there's any outstanding concerns or suggestions from Hofwig and the community councils.
Ma'am, just before we start this session, if I may just have a brief moment for the council representatives here to come forward to the table in case we get into a technical discussion.
Yeah, that's fine. Actually, I'll take a short break. We're doing well, but I'll maybe just take a break till 1:45. That's 10 minutes.
Thank you.
Again, I just had to reopen my documents because my computer did a Windows update at some point, closed everything down. So we were going to come on to condition 36 on operational noise. And as I said, it'd be helpful to just look at the extent to which the condition that's now been agreed between the council and the applicant picks up on the various matters that Hofwig and the community councils had raised in the details they submitted in the original community hearing sessions. So who would like to explain the basis of the condition as it is? Mr. Brooks.
Sure, I can start. Yeah, so so the basis of the condition is essentially we went through a process where we started off with a proposed planning condition on our side related to operational noise, and through discussion with Aberdeenshire Council, we've implemented some changes that they requested to that proposed condition, and we've come to an agreed condition between RES, the applicant, and Aberdeenshire Council.
Just adding to that, normally you would expect, or we will put forward to inquiry, a condition purely based on ETSU, the ETSU approach to rating. Aberdeenshire requested that we adopt a slightly different approach based on predicted levels plus an allowance. We've been content to go along with that. So what you see here is a bit of a hybrid between ETSU and the Aberdeenshire approach. I don't think it makes much difference to the levels, but Aberdeenshire will be able to expand on that.
Okay, Council.
Yeah, ma'am. The Aberdeenshire approach is to try and restrict to noise emission levels at receptors rather than the full ETSU limit with an allowance, to avoid really one developer taking all the headroom that's potentially available and ending up in scenarios where we end up with complex cumulative conditions down the line that potentially are unenforceable.
Thank you. So it might be helpful for, I mean, you might have already been able to look at the agreed condition and see whether it meets your concerns. Otherwise, you know, you could perhaps summarise what your outline questions were, and we can ask whether they're covered.
Thank you, ma'am. I'm familiar with the normal approach that Aberdeenshire Council takes, which is kind of epitomised in the Glendy wind farm decision letter, decision notice or decision, where the noise limits at nearby properties, of which there were about 11 or 12, I think, were basically the predicted noise emissions from the wind farm plus a margin of 2 decibels. However, what I note with the proposed condition that's from the Council and RES is that rather than simply adding a margin of 2 decibels, they've first of all set a minimum of 30 decibels for every property, and then allowed 3 decibels where the noise, predicted noise, goes above 30 decibels. They've then added 3 decibel allowance over the predicted noise. So I have a question really, which is, so in this proposed condition there is also included the reference to excess amplitude modulation and the calculation and rating of an AM penalty. And in that note 5 it says, it tells us the document that they'll use for calculating the penalty. So the penalty will then, it says that the level of amplitude modulation will be converted to a penalty in decibels. And well, perhaps I'm assuming too much, but that suggests to me then that that penalty would be subtracted from the initial noise limit, and there would be a new noise limit, which would be what's proposed in their condition minus the penalty. However, when you look at the actual figures, there are some locations. So if I take an example of, I'll take the most extreme example, right, which is the property identified as house H111. So house H111, the predicted noise emission in the applicant's document 001018, table 1215. They predict that the noise emissions from the turbines at H111 will be at the lowest wind speeds 9.9, and then they rise to a maximum of 21.7 decibels at 12 metres per second wind speeds. The proposed noise condition would set the noise limit at H111 at...
Take your time for the report. Towards the pen.
Sorry? Oh, yeah, sorry. Yes, yes, yes. So,
If you just start at the proposed noise condition. That's fine.
yeah. So the proposed condition is 30, and that is 8.3 decibels above the predicted noise emission from the turbines. So my question really is, so if there's an AM penalty and it is 5 decibels, say, then, and it is house H111 which has been suffering from AM, the excess AM, how is that penalty going to impact them or mitigate the nuisance that they're suffering from AM, because the noise limit would then be 25 decibels instead of 30, but that is still above the predicted noise from the turbines, and therefore implies that the operator would not need to take any action whatsoever to change any of the output from the turbines.
Okay, could you explain how that works?
Yes, I'm happy to answer that, Mum. So yes, so what we've done is applied a minimum noise limit of 30 decibels, as you point out, where the predicted levels are lower than that. That's really to reflect the practical reality of trying to measure noise levels which are so low. So with the equipment that we have today, Class 1 sound level meters, the self-induced noise for that equipment in a perfectly silent environment with no change in sound pressure level would be around 20 decibels. That is the noise floor of the sound level meter. For us to be able to measure levels accurately, we generally need to be 10 decibel above the noise floor of the sound level meter. So what we're discussing here are levels which are extremely low in absolute magnitude. So it's really to represent the practical implications of trying to demonstrate compliance when you're trying to measure something which is so low in level that it's challenging to measure.
Hold on. That wasn't what she had. If I may.
Yes, sorry about that. Yes, so my colleague has suggested the other part of the question was in that situation where we do measure noise emissions below 30 decibel, which include the application of a penalty for excess AM. What would we do in that situation? I think that's the point that you were making there. So say the noise level we do manage to measure is 25 decibels, for example, and we apply a penalty for excess AM of 4 decibels, we would be at 29 decibels, and we would still be within the noise limit of 30 decibels. I think that's the situation that you're suggesting there. So, again, in the first case, if we are to investigate excess AM and apply the methodology to calculate a rating penalty, then in the first case, Aberdeenshire Council would put in their written request to us that they agree that there's an issue of amplitude modulation, and we would go through the procedure of trying to measure and calculate the AM rating penalty. In the situation where, for example, in this case, that rating level would meet a noise limit of 30 decibels, even with the addition of an AM rating penalty, then the site would comply with the planning conditions in that regard. Again, it's worth mentioning that 30 decibels is a very low noise limit for rating levels. But in that case, that doesn't restrict the council from taking statutory complaint proceedings to try and resolve that issue if they still determine that that is a valid consideration.
I note that in the background noise surveys, you were able to measure down to 22.5 decibels.
Yes, so we can measure down levels lower than 30 decibels, but my point is that those measurements we have below 30 decibels, they will also include the self-generated noise of the equipment. And that will actually influence the readings we get there. So when we do the background noise surveys, and according to ITSU, essentially any levels that we measure below 30 decibels do not have an impact on determining the noise limit under ITSU R97.
Mr. Backwell, did you have a question?
Yes, can you remind me what is considered the background levels? And I'll refer you to House 139 in particular, because I was present when the recording equipment was set up. Sorry, this is nighttime noise levels.
Yes, so information on the derived background noise levels is in Chapter 12 of the EIAR, dealing with acoustics. And the property that you're relating to, I think, is Craig Shannock Cottage. Yep. So at low wind speeds, for example, a standardized 10-meter height wind speed of 1 meters per second, the background noise level derived was 28.3 decibels. And this increases to 35.3 decibels at a standardized 10-meter height wind speed of 12 meters per second.
What would you consider to be a nighttime noise level in a quiet rural area?
Ma'am, I'm getting concerned this is turning into a discussion about acoustics and the substance of the issue. We're here to discuss conditions. We can drift very easily into an evidence session on acoustics.
I'm sorry, I don't agree with that. I think it's important to understand the, no pun intended, background before we discuss how it's to be managed and controlled. Thank you.
If you've got a question that frames it in terms of helping you understand the condition, that's fine.
I think where I'm going with this discussion, and I take Mr. Trinnock's point, is that you can frequently hear the sound of silence around my house when you go out in the evening and at night. And to get a low background level is difficult because of the sound from the machine. I'm just trying to establish what the reality is for most of the people who live around the hill, particularly the ones that live away from roads, and particularly in the evening and night, ergo getting sleep.
So, and I've seen the written submissions on the concerns about nighttime noise, and you would need to go on the process you've gone through, basically. The recordings you've made.
We've heard the comment, but we really are not in a discussion about acoustics in this session. It's about conditions.
Okay, and you can, you know, if you want to relate these points to the condition, you can include that in the closing submissions. Then if the applicant needs to respond, they can do.
It's not a facetious exchange, this. In order for us to understand how the menace of noise in a very quiet environment is to be managed, if this development is permitted, we have to understand what the background is. And I don't intend any pun by using the word background. Mr. Backwell is here to, and is qualified to do this, to A, explain the background, and B, explain his understanding of how it should be managed, or could be managed. And I perceive that that is what he's trying to do for your benefit.
Okay, is there anything that is relevant on how the condition deals with nighttime noise that you can add, or should we move on?
We're going to get in the mire if we go down this road. We really, really are. The figures are all there on the EIAR. We've had further written submissions on noise. We're here to discuss the wording of conditions. We have no more to say.
Okay, I'm just asking because I've only recently seen the final condition myself and I wasn't sure whether there might be something in it you wanted to draw out, but I hear you.
Well, we record then that there's no willingness on the part of the applicants to discuss the issue as we have framed it. That's fine.
Ms Patterson, Ms Bick, sorry.
Yes, sorry. So I would just like to come back on my initial point that other wind farm operators have been content to accept lower than 30 decibels as noise limits. And although current technology may not allow for consistent and perhaps dead accurate measurement below 30 decibels, that does not preclude there from being a technological improvement which allows it in the future. And therefore, I believe that that the noise limits for the property list in the proposed conditions should be set with reference to the predicted noise levels in table 12.15 of 001-018 plus a margin of 2 decibels as per the Glendy wind farm decision. Because that the applicant has already, in their calculation of those table 12.15 numbers, has already added a 2 decibel allowance for uncertainty, as they call it, and then they would get an additional 2 decibels allowance for uncertainty. So they have 4 decibel allowance for uncertainty already, and I think that should be quite sufficient for them.
Does the council have anything more to say on the noise condition based on what you've heard?
Just on that point, I mean, we wouldn't oppose 2 decibels, 3 decibels. It's either or for us. That's all really I have to say. We wouldn't oppose a suggestion of a plus 2 dB to predicted emission levels.
Well, we have an agreed position with Aberdeenshire Council for the purposes of this session, and I hope that we still do. The answer to the point being made very fairly is that the levels which have been agreed with the council are already below the advised ETSU levels. And although there may be a sound level meter sometime in the future which may be able to measure below the floor level of the current meters, that's quite a gamble in terms of imposing. There's very little point in imposing conditions if you can't measure compliance because the floor level of the meter won't do it. That's the point. There may be something in the future, there may be fusion in the future, but it's not here now.
Sorry, ma'am, the point I was trying to make is the difference between the actual levels received by the people in their houses and the background levels that they're used to. And even with an open window, they're going to hear them. And I would like to ask Mr. Brooks what he thinks. Would he think that if you can hear a sound and it annoys you, is it a nuisance?
That's not really a matter for the conditions hearing session, though. and I will review the written evidence on the nighttime noise concerns.
Ma'am, would you permit one more point that is relevant to a measurement of sound that isn't in ETSU?
If it's relevant to the wording of the condition.
I would like to ask Mr. Peter Brooks, I'll leave out the leading edge erosion question, but what ground absorption factor would you use when the ground is frozen? I have a reason for asking this, ma'am, because I have an answer from Dick Bowdler.
Could you just put your microphone off a second? I think this was covered in further written submissions. This noise, there's been further written submissions on the frozen ground point. Okay.
I'm just seeking an answer from Mr. Brooks.
I'm not seeking an answer from Mr. Brooks. Okay. I'm going to move on to the next point.
I just make one. Once again, we have an informative. The Community Council has proposed to set up an independent group to monitor noise and ensure compliance to the conditions, as well as a rapid response to complaints from the community. This is proposed to be set up for 5 years in the first instance to cover pre-construction, construction and post-construction activities. And just getting away from the technical thing, we live in a very quiet rural area and we're just trying to minimise the nuisance of noise. So I know it sounds very technical, but 3 dB is a hell of a lot more than 2 dB. Thank you.
Okay, and you can respond on that informative point as with the others in your submissions.
To a point, but I think Aberdeenshire Council should also be asked for a view here, because you're busy people, and in a complaint-driven system, the idea is that you get approached by a complainant, but to have an entire group liaising with you all the time may or may not be welcome.
Has the council seen this informative as it was set out in the late submission from Hofwig and the community councils?
Thank you, ma'am. We did have the documents. We would probably still want to cover it as a more general point in our closing submission, because I think that the principle of community group involvement is something that is going to be applicable across a number of the conditions. However, as a council, we have our enforcement function, we have our enforcement charter that sets out how we deal with complaints, and that is the approach we would likely take, regardless of the development, and regardless of the location of the development. We have our procedure that we follow.
Okay, thank you. So we'll see that when the council puts its submissions in. Okay, I'm going to move on to Meikle Tap Mast. I'd asked whether a condition was needed on this, and I think one's been circulated now. I think, has everybody seen that? Have you seen that, Mr. Campbell?
Makes the point that he requires, as I said earlier on this morning, the mast for the functioning of his business. So any scheme which is devised to minimise or eliminate possible interference with the mast would require his approval, and specifically the approval of the contractors who maintain the communication system which he operates. He tells me that his business depends upon reliable communications for obvious reasons. We've only seen this condition yesterday evening, and no doubt there'll be the ritual apology, which of course would be accepted. But we need time to understand what is proposed. Is this a condition which would be discharged before the commencement of development, or would it be something that is devised as we go along? Or do we wait until the turbines are erected?
Yeah, Mr. Trinnick, you can respond to that.
It's not a ritual apology, it's an apology which is meant and which is offered when it is due. So less cynicism, please. We do apologise that this is coming late, and we mean the apology.
It's gratefully accepted.
Thank you very much. You can see that the turbine prescribes, the condition prescribes that it is not a pre-commencement condition, but we mustn't erect a turbine until the scheme which has been laid down in the condition submitted to and approved by. Now, I can entirely appreciate that the owners of the business would want approval, but I can't write a condition requiring the approval of the owners of the business. Only the planning authority, by law, can approve matters under conditions. Clearly, if you wanted to add some consultation in there, that's absolutely fine. I cannot imagine for one moment Aberdeenshire Council would do other than consult with the owner of the mast before approving a scheme under a condition. But I think that condition does achieve the purpose, which does provide for the remediation of any interference. We could have tried to define levels of interference and what's serious and what's not. We didn't. It's any interference with the operation of the mast attributable to the development. I think that's as far as we can go at the moment. Not trying to be too clever.
Does the council want to say anything on how it would consult on that?
Based on my experience with the council, it would be quite uncommon for us to be consulting with private individuals on these matters. But I appreciate the intent that this is to, I suppose, prevent an issue arising for a particular business. It may be helpful for agreement of the scheme to be part of the scheme, if that makes sense. So whenever the mitigation is submitted to the council for approval, that includes a record of agreement by the operator. We would have concerns about being able to unilaterally agree such a condition as local planning authority, because whether we would have the expertise to agree the mitigation, also are permissions in place for the mitigation to be carried out, for example, that may depend on agreement with the business. So I think that the agreement of the scheme should be part of the scheme, if that is helpful, if that makes sense.
Okay.
I had a look at the standard conditions, and the proposed conditions are very limited. There's no baseline suggested, no baseline measurement for TV and radio, no claim procedure, and it just focuses on the remedial activities. So I would suggest that actually it needs to be a little bit more expanded to include a baseline survey and a clear claim procedure, as is stated in the standard conditions.
Yes, it's an exclusive use mast.
Yeah.
It's an exclusive use mast, which has planning permission. So I beg your pardon. You should know that this is an exclusive use mast, and it has planning permission.
Do you have any response to the comments on the model condition breadth?
Well, I'm not a fan of the standard conditions, you may realise by now, but they are what they are. The scheme will specify what it needs to specify in order to address the issue, but I have no objection whatsoever to adding in the reference to a baseline and the other references in the standard condition. If that helps, then fine.
It does help. And although I understand Mr. Hewitt's reticence about including the consultation with a non-official body, if you like, the circumstances here are a little bit special because it's an exclusive use mast, and this is a large employer in this part of the world, so we want the business to work.
So I'm sure you can discuss between you and how that provision about the agreement might be written in or what that would look like. So I don't have any more proposed conditions on the list to discuss. I'd go back to the original agenda for the other sections, though. And agenda item 4, I had other conditions, and I'd listed some suggestions made in hearing statements that at that time at least weren't discussed under the conditions in item 3. The first we discussed in policy is the idea of best fire risk or containment or emergency response provisions that arose from the Community Council's hearing statement. Is there anything in the conditions that addresses that to any extent?
So I think we discussed, sorry, let me just scroll to where I've got it. Yeah, so the applicant would be prepared to amend the condition dealing with the design of the energy storage. And this... Yep.
I think that's condition 9.
Just scrolling up 2 seconds. Yeah, so that's condition 9. So I think, per the discussion during the policy session, I think the decisions that are before the inquiry are quite clear on the Scottish Minister's view that fire risk is not a material planning consideration. The 2 decisions that were submitted by Hofwig yesterday deal with 2 specific points, and that is arrangements for access and water supply for emergency services, and therefore the applicant would be content to amend condition 9 and add a final sentence which says details of arrangements for access and water supply for emergency services shall also be provided.
Thank you. So does that...
Yes, I think that would be acceptable.
Thank you. We've covered the private water supply discussion, and I'd referred here to Claire Watt's submission, written submission, but I'm happy to, I can look at that myself, and parties can look and see if there's anything in there they want to respond. They weren't so much comments on what Conditions Park could do, should do. I think there were more questions. I think Mrs. Watt was really interested in what are the bounds of how conditions can be used. So there may or may not be things in there that parties want to respond to. Is there anything else on conditions that parties would like to raise? No? Okay, then I can close the hearing session. So I'm just finding my script. Okay, so that brings us to the end of the conditions hearing session, which is the last programmed session for this inquiry. Before I close formally, is there anything across the inquiry that people need to raise while we're still in session?
Yes, ma'am. 2 things. I'd like through you to thank Mr. McIntosh of Aberdeenshire Council for arranging these premises, which have been very convenient. It's not always understood the extent to which a large public inquiry puts stress on various aspects of a community. And I hope you'll agree that Hofwig has responded satisfactorily, and the community councils likewise. On their behalf, ma'am, I'd like to thank you for the conduct of an orderly process, and we're pleased to reach this point without stepping into too many bear traps. But That has largely been due to your organisation and that of Hazel Bailey, for which we're most grateful. Thank you.
Thank you very much. That's very kind of you. Any other comments people want to raise?
Yeah, it was just to, probably it's our mistake, but to just reiterate, or for you to reiterate, the order of closing submissions and the dates you have for them, because it just listening to the debate this morning, it's clearly important that we have a chance to comment on Hofwig and the other submissions, particularly as to conditions, so that
Mr. Finlay, for raising that point, I should have done. To be blunt, ma'am, the amount of time allowed for a closing submission in a case of this length is a little short. And so, pleading self-interest, I'm going to ask you for another week, because I do not think I can complete the job in the time presently available. Not because I have extensive other commitments, because I'm ostensibly retired, but because there is a lot to get through. And much of that time will be spent listening to the tapes, listening to the videos to make sure we get the evidence right. So that's my request. That would knock everybody back a week, and I just hope that's acceptable to you. But if it's not, it's not, and we'll manage.
And Mr. Finlay, is it specific aspects of the comments from Hofwig that you'd want to see and respond to, or all of them?
it's primarily the conditions that, because the way various matters have been left is that I understand Hofwig are going to be advancing various matters on conditions. And obviously, the detail of that will be up to them. It's primarily those matters. I should say I don't think we'll need very long, having received the Hofwig submissions, to add comments to them. But in order not to create a split timetable, we prefer a short period after Hofwig have made their submissions before submitting ours.
Is a week long enough?
Absolutely.
So what I suggest I do is extend the Hofwig written submissions date by a week. So that's 3 weeks. The council's to a week after that. And the applicants to a week after the council's. Is that okay with everybody?
What date does that give me for closing? Trying to work it out.
Let's go from the calendar. Yeah, so you'd be the 29th for Hofwig. It's not my normal computer, so I haven't got a calendar on it. That's a Monday. Monday the 29th for Hofwig. The following Monday for the council would be, somebody tell me, the 6th. So you would be, 13th. Okay, I'll get the case officer to confirm those changes for written submissions then. Any other comments? No. Okay, and like Mr. Campbell, I'm also grateful for everybody who's taken part in the inquiry. There's been quite a big input from quite a lot of people, as well as all of those who've participated, including the people from the communities. I also want to thank the people who've come out to observe all of the sessions and support the participants, particularly the community participants who gave out their statements on Monday night. And for those people for showing an interest in the case, the inquiry process. I think some of you have sat through almost all of the sessions, which is quite an undertaking. And like you, I'd like to thank Mr. McIntosh for helping with the hall. And it's meant you've had to be here early and late every day, and I'm very grateful. My report is due to be submitted to the Scottish Ministers by the 20th of January, and they'll consider matters from there and make their decision in due course. I am hoping to make my report earlier than the closing date. I'm thinking of undertaking a further site visit to the stone circles later in the season, just so that I've got another view of it at a different level of leaf cover. But that shouldn't delay matters beyond the sort of timescale I already had in mind. So that's us finished. I'll close the inquiry. Thank everybody again and say goodbye.